Good evening to you all. My name is Christophe Paulus. I would like to welcome you to a new Supranational Criminal Law lecture at the Astor Institute. And like the previous lecture, I would also like to extend a special word of welcome to the participants, not only the participant but also a lecturer of the Summer Law Program on International Criminal Law and International Legal and Comparative Approaches to Counterterrorism that the Astor Institute is organizing now for the 11th time in cooperation with Washington College of Law. Now, for those of you who are not familiar with the Supranational Criminal Law lecture series, this is a lecture series on international criminal law and has been organized since 2003 by the Astor Institute in cooperation with the Coalition for the ICC and the Grotius Centre for International Legal Studies. Now, tonight's lecture is entitled Fixing the Law Governing the Relationship Between Hate Speech and International Crimes, and is provided by Professor Gregory Gordon. Professor Gordon is Associate Dean and Director of the Research Postgraduate Program at the Chinese University of Hong Kong Faculty of Law. And he has a very impressive and long CV, and it's impossible to read it to you in its entirety, but let me just name a few elements particularly related to international criminal law. Now, prior to joining the Chinese University of Hong Kong, Professor Gordon was a tenured faculty member at the University of North Dakota School of Law and director of the University of North Dakota Centre for Human Rights and Genocide Studies. And he has also worked with the Office of the Prosecutor for the International Criminal Tribunal for Rwanda, where he served as legal officer and deputy team leader for the landmark media cases, and so the first international post-Nuremberg prosecutions of radio and media print media executives for incitement to genocide. Now, for this work, Professor Gordon has received a commendation from Attorney General Janet Reno for service to the United States and international justice. Professor Gordon has also worked with the Department of Justice Criminal Division's Office of Special Investigations, where he helped investigate and prosecute Nazi war criminals and modern human rights violators. He has also prepared prosecutors for the Khmer Rouge leadership trial at the Extraordinary Chambers in the courts of Cambodia and Phnom Penh, and he has trained lawyers and judges at the War Crimes Chambers for the Court of Bosnia and Herzegovina. Now, as regards to the academic world and the academic dimension, his scholarship on international criminal law has been published in leading international academic publications. Now, tonight's lecture revolves around his new book. There it is, Atrocity Speech Law, Foundation, Fragmentation and Fruition, which introduces a very interesting new approach to the law governing the relationship between hate speech and international crimes, and has already received excellent reviews. For example, the ICTY prosecutor, Serge Bramart, called it the definite source for prosecuting atrocity speech in international criminal law. So, Professor Gordon, thank you so much for being with us tonight, and you have the floor.
Appreciate it. So, thank you all for coming. It's a great honor to be here tonight. This is the week that the book is going to be published. So the actual official publication date, as you see there, is June 16th. So at the end of the week, it will actually be published. And I have the advanced copy, if you will, in my hands. Oxford University Press just sent this hot off the press. This is my great photo op moment. So I have to hold up the book and see if I can. I've got somebody taking a photo of me, I think. Great, thank you. I'm kind of excited to have the book be in my hands for the first time. So let me tell you a little bit about what I'm going to discuss with you tonight. And I think this was working before, but there we go. I want to talk about the key issues that the book deals with to start with, to kind of situate why I think this book is important at this time in terms of the development of the law. And then I want to kind of do an overview of the chapters in the book, and the structure. I'll talk about problems with incitement, in particular incitement to genocide, and suggested solutions, hate speech and persecution, or as persecution and suggested solutions, and then instigation and ordering. Those also have issues, and I have some suggested approaches for dealing with those issues. And then finally, those are, if you will, the micro analyses that I do in the book. And then I do the macro analysis, which is my unified liability theory for atrocity speech law. So that's where I look at all of the offenses and try to find a way that we can make them work together. As of now, as my book title suggests, it's a fragmented area of the law. So let's talk a little bit about the first issue that I think required me, from my perspective, to feel like a book on this topic needed to be written. There is this body of law that's developed since the end of the Second World War, and it governs the relationship between speech and international crimes. There's a good amount of jurisprudence out there, but experts have not treated it as a distinct body of law with its own name. It's been called everything from incitement law, which I think is too narrow, because as we'll see, incitement is only one part of it. It's been called just international hate speech law, which I think is too broad. And so the first solution that I offer in the book is to give it a proper name, because I don't think we can talk about it as a body of law unless we give it a proper name, and that name, which I think captures the scope and gravity of it, is atrocity speech law. So I'm hoping that that will now become common phraseology when we talk about this area of law. The second issue is, as I alluded to a moment ago, is that it's a fragmented body of law. It is accumulated in kind of a helter-skelter way. There have been cases that have come up. Jurists have had to deal with the cases, and based on that treatment, there have been rules that have developed, but never with the idea that those rules should be considered vis-a-vis one another. And so what we have is this fragmented body of law, both with respect to the individual modalities. So I would say that we can think of fragmentation in the sense of, each of the modalities, incitement, persecution, instigation, ordering, are broken sort of within themselves. But then in terms of how they all fit together. So what I want to do in the book is kind of go back to the origins and understand how this came about. Because my thought was that if I could understand how the law, became so unruly or so difficult to understand as an entire body, maybe I could explain how we could fix it. So that was the approach that I took in tackling this book. The other thing that I think arises out of this is, and it's interesting, is fragmented scholarship. So what we have now is individual articles. A lot of individual articles, for example, on incitement, book chapters. You see a lot of anthologies that put together different themes related to aspects of incitement. Here and there, they touch on persecution, hate speech is persecution, but not that much. Mostly, it's about incitement. There's kind of an obsession with incitement. I talk about it as a fetish in the book, really, that it has kind of talismanic significance. Part of that is genocide. It has a dark power of its own, right? The word incitement and genocide, those two words kind of brim with a kind of dark, scary, I think, associations and imagery. And yet, we've got to get past that, because honestly, and as we all know, genocide is extremely difficult to prove, and incitement to genocide no less. The other charges I submit to you are a lot more realistic in terms of charging strategy and in terms of potential success in the courtroom, if we really want to make sure that we're bringing to justice people who use speech as a weapon to foment mass atrocity. So this book is the attempt to bring it all together and look at it, step back and look at it holistically. The stakes I submit to you are quite high. There are active cases, such as right now, the case against Gbagbo that's going on in the court here in The Hague as we speak, and his top lieutenant, Blade Godet. There are other, obviously, speech-related crimes that are being committed as we speak. I have the leader of ISIS just as a convenient example here in my photograph, but there are, unfortunately, many other examples that we can think of. We know, for example, that the Sechel case is being appealed, that there's a significant speech aspect there. Mugesera from the Rwandan genocide, who was convicted last year of incitement to genocide is also appealing his case. So in addition to cases that are in trial stage or, what we can imagine would go to trial, we have cases as well that are on appeal. So it's very important that we get the law right, and I'm hoping that the policymakers, the judges, I'm very pleased to see Judge Van Meijgaard here tonight. Welcome, nice to have you, who can make a difference, I think, in terms of seeing that the law is dealt with in a proper way. I just hit the wrong button. All right, so now what I'd like to do is talk about, you saw in the subtitle of the book, of course, it's Foundation, Fragmentation, Fruition. What I'd like to do right now is talk about, those are the three dividing points of the book, conveniently enough, which we see in the subtitle. Chapter 1, I look at speech and atrocity from an historical perspective. And I talk about, I go back to the Armenian genocide, and I talk about the role that speech played in that. I look at the Holocaust. I look at the violence in the Balkans in the 1990s, the Rwandan genocide, and more current examples. In Chapter 2, I talk about international human rights law and how hate speech is treated there, as well as in domestic jurisdictions. And then, with that foundation, in Chapter 3, I look at the birth of atrocity speech laws. I call it Part 1, which is Nuremberg and the foundational statutes of the institutions that I've been talking about, the ad hoc tribunals, the International Criminal Court. In Chapter 4, I look at the birth of atrocity law, Part 2, and here I look at the foundational cases and the offense elements that developed as a function of those cases. In fragmentation, I look at the problems that have arisen from this foundational aspect. Chapter 5 deals with problems regarding the crime of incitement to genocide. Chapter 6, problems regarding persecution, instigation, and ordering. And Chapter 7 deals with the liability gap in reference to hate speech and war crimes. So, we've seen the foundations. We've now seen in the book the problems that have arisen. And so the last part of the book deals with solutions. There's a very kind of logical order, I think, to the book and the sequence. In Chapter 8, I talk about fixing the problems with incitement to genocide. Chapter 9, persecution, instigation, and ordering. And then in Chapter 10, I talk about adopting a new crime of incitement to commit war crimes. And then finally in Chapter 11, that's the restructuring for the unified liability theory for atrocity speech law. So that's the overview of the book. Let me sort of break down with you some aspects of each part of the book. And let me just say that as I'm about to do that the book kind of tells a story, right? If you think of this as just a dry law book that, you're like, oh my God, 450 pages of all these rules and, talking about all the different, problems with, this rule versus that rule. I think that's the wrong way to look at this book. Actually, I think the best way to look at this book is as a story. And in a way, I really wrote it as a story. I begin with the laws passed. I tell about the history of this series of crimes, if you will, and then of course I look at the laws present. How there have been problems that have been developing over the last few years, especially, and then the future. What we can expect for the future. So I like to look at this book as telling a story. All right. So now I think with that context, let's break it down a little bit. And we begin with Chapter 1, as I pointed out, is an overview of the history of speech and atrocity. And I do go very far back, all the way to Amenemhet I, who used words that arguably dehumanized his enemies and led to atrocities, to Cato the Elder in the Roman Republic and Empire, Pope Urban II, and the infamous Belgian King Leopold the second, sorry about that, Judge Van Weingart, but he was not the greatest Belgian, I would submit to you. Present company is a much better example. We have obviously a very long. I think the point is we see the ancient roots, if you will, of this phenomenon, and then looking at the 20th century, as I said, the Armenian genocide and the Holocaust, Julius Streicher being one of the big culprits. I do have Goebbels on the book and on the cover of the book, and I do think Goebbels should have been in that dock in Nuremberg, of course, and if he hadn't committed suicide, he would have been. And in a way, this is my way of trying Goebbels myself, which is very gratifying to me. And then going to the post-Cold War world with the Balkans, we see Radovan Karadzic and Cantano Habimana, one of the infamous announcers from Radio Television Libre de Mykolaiv, the radio machete from the Rwandan genocide, up to the horrible situation that we see happening in Myanmar today with extremist Buddhists who are attacking the Rohingya Muslims. And so we can see that, as I talk about the fact that this stuff is going on as we speak, that this is a deep chapter of history that goes up to the present. We also then can look at international human rights law and domestic law. And the main point I want to make here is that there's a kind of I talk about two poles, if you will, that I think are manifested in the ICCPR, right, the International Covenant on Civil and Political Rights. We can see it in Article 19, right, which tells us in Article 19.1, everyone shall have the right to hold opinions without interference. That's a basic guarantee of free speech, right? And then we see the converse in Article 20. Any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Now, I see that some of my fellow countrymen are here today, the folks from American, welcome. And we, as Americans, know quite well that we are the most speech-protective country in the world. And so you can see the United States on one end, right, which is incredibly speech-protective. And then on the other end, you have really most of the rest of the world that doesn't have a compunction in terms of prosecuting hate speech when it involves racial, ethnic, religious animus, and that obviously has a potential to lead to violence. In the middle, we have Canada. And Canada's an interesting case study. And in Chapter 2, I talk about it at great length. The book is heavily influenced by American jurisprudence, and so I do spend a good amount of time talking about U.S. First Amendment cases in the second chapter. So for those Americans who think, that the First Amendment should get its due, given especially that I will, to some extent, not be in line with probably orthodox First Amendment philosophy, just know that there is a fairly lengthy exposition in there. From all this, I'm able to sort of lay the, if you will, jurisprudential stakes out and talk about what the framers of international criminal law in its early days would have had to consider in coming up with crimes that were related to speech and the core crimes that we're all familiar with. And if we look at Nuremberg, we can talk about crimes against humanity and war crimes, and then ultimately we're looking at genocide. So in Chapter 3, I get onto that. And the chapter begins with the Nuremberg Trials. I do look at Julius Streicher, the editor-in-chief of Der Stürmer, and Hans Fritzsche, head of the radio division in the propaganda ministry in Nazi Germany. I also look at Otto Dietrich, which is a case that has been overlooked. Dietrich was press chief for the Third Reich and actually, in many ways, was just as powerful as Goebbels. Everything related to newspapers in Nazi Germany he controlled, including the newspapers that Adolf Hitler read on a daily basis, which he selected. And so his case is fascinating, and in a moment I'll talk about why it's so important in relation to hate speech as persecution. I also talk about the Genocide Convention and the origins of incitement to genocide through the great mind of Raphael Lemkin. And I talk about the International Law Commission's draft code of offenses against the peace and security of mankind, both the early version from 1954 and the later version from 1996. Those I look at as the true roots of this area of law, and those then translated into the provisions that we see in the ICTR and ICTY statutes, as well as the Rome Statute. And what we get from those are incitement to genocide, hate speech as persecution, instigation, and ordering. And remember to keep Dietrich in mind. I will come back to it. Chapter 4, remember I said this was the birth of Atrocity Speech Law, Part 2. These are the cases and the elements of the crimes that were fleshed out in those cases. And as you can see, I've got the 4 crimes laid out here, and I picked a couple of representative cases that I thought were helpful just for purposes of this presentation to give you a sense of where these elements came from. We see the media case, which Christoph talked about, that I worked on myself at the ICTR. Nahimana, Fernand Nahimana being the chief defendant there. We have the Akiezu case, quite famous. Most people might think of it just in terms of the first genocide case, but it was also the first incitement to commit genocide case. And then Rougiu, prosecutor versus Georges Rougiu, who was an RTLM announcer, another case that I worked on, and Kupreskic from the ICTY. We have instigation, we have Samanza and Orich, and then ordering, Blaskic and Kamuhanda. Now, again, these are just some representative cases. They're not the only ones. But let me try to share with you the basic elements, as I say, that come out of these. So with incitement, the elements would be direct, public, incitement itself, mens rea, which is double layered, the intent to incite, the intent that genocide take place, and then I've got causation as a question mark, and I'm going to talk about that in a little more depth in a moment, but it's a question as to whether causation is an element. Persecution, we have it as being part of a widespread or systematic attack against the civilian population with the knowledge of the attack, a severe fundamental group rights deprivation that's motivated by the group's status, and that is at the same gravity level as the other crimes against humanity acts that we know, for example, as enumerated in the ad hoc tribunal statutes, as well as the Rome Statute. Instigation is prompting another to commit an offense, resulting in the commission of the offense, intent that the offense be committed, and then a connection between the prompting and the crime. In other words, there must be a contribution. And then finally, ordering, the transmitting of an unlawful command by a superior to a subordinate with an awareness of the substantial likelihood of the crime's commission and when the crime, again, is actually committed, as we saw with instigation. All right, so we have our basic elements. What I propose to do now is to talk to you, because remember, as I said to you, I would look at the problems within each offense, right, within each modality. Now that you know what the elements are, this is kind of my way to give you the context for talking about the problems. And because, this is a 450-page book, and there are a lot of problems with the law, I'm not going to be able to cover them all tonight. What I thought I'd do is give you a sample of what some of the problems are, hopefully to whet your appetite to read more. And then you'll get a chance, I think, hopefully if you get the book, to explore that. So let me begin with incitement. And let me guess that hopefully that jarred you and brought you out. I thought that slide was good to sort of remind us how ugly this crime really is. And let's go back to the elements. And what you can see, what I want to do is in blue, I want to look at public and I want to look at causation. Now in my book, of course, I look at the other elements, but we don't have the time for that tonight. So let's talk briefly about the public element. What I want to focus on is, in particular, the so-called roadblock cases, because they give you an idea of the problem with public. The decisions veer wildly, some finding that roadblocks are quote-unquote public places, because they're located on public roads, and others reaching the opposite conclusion because members of the public, in quotes, were not present. Others deal with the problem differently. They look at the numbers, right? How many people were there? Was it large enough to constitute public? Should that be 100? Should it be 200? Well, we don't really get a lot of great guidance, unfortunately. And other cases have found that the speech was public because the speaker's voice was electronically amplified. But why should that matter? When you read those cases, you're thinking, electronic amplification, that makes it public? Really? Okay. And then, why is public incitement more potent than private incitement? Think about that for a moment. If anything, being in close physical proximity, I submit to you, to the speaker would arguably arouse more of an emotional response than merely hearing a disembodied voice crackling over the airwaves of a radio transmission. And yet, for some reason, we consider the public to be the more potent variety of incitement. I would submit to you that it would depend on the specific case, right? All right, so what's my solution? I deal with that. Remember, in the latter part of the book, when I look at fruition, this is in Chapter 8. In Chapter 8, I look at fixing incitement to commit genocide. One of the things that I point out is that it's really not feasible to define public. Why should advocacy to 10 persons in a mostly deserted public square, again, I would put that in quotation marks, be considered as incitement more than a speech made to 300 persons at a private residence, at a mansion, say? I mean, that seems ludicrous, and yet that's kind of what we're dealing with here. And so my solution is to eliminate public as an element. It's funny, my good friend and colleague Michael Ramsden is here, and a year ago at this time I was in The Hague doing research for this book, and I remember specifically working on this, and I remember having that chat with you about the public element. You and I had a nice dialogue, so it's particularly gratifying to have you here tonight, Michael. But what the point is that what I think is that we should eliminate it as an element. We don't need to have it as an element. If you think that in a particular case the fact that it was public was an issue, then deal with it at sentencing. It shouldn't be a function of liability. It should be a function of punishment, in my opinion. That's the solution, I believe, for dealing with the public issue. The other one that I want to talk to you about is causation. Although in the legal sections of the cases, the ICTR indicates that causation is not an element, it seems to be analyzed in the factual parts of the opinions. So if it's not a legal element, why talk about it in the facts? It creates a tremendous amount of confusion, and many scholars have postulated that, in fact, it is being treated as though it is an element. And in the exposition on the development of incitement to genocide, I talk about many of the ills of the Akayesu case. I talk about sort of the original sin of Akayesu because it is very loose in terms of differentiating between the French and English versions of words. And it causes tremendous confusion, right? Because inciter in French is essentially the same as instigate in English. And so, whoa, what do we do here? We've got a tribunal that's working in both English and French. We have a statute that's written in both English and French. And unfortunately, I think the Akayesu panel was timid in making choices and sort of tried to mediate between the two and caused great confusion. So there's, as I point out in the book, there's a lot of confusion in the jurisprudence between incitement and instigation. And one of the effects of that is causation. And not being clear on whether it's an element, right? Because it's an element with respect to instigation. And others have suggested that it's maybe just because the judges are not comfortable with the idea that just on the basis of speech, you could convict somebody of as heinous a crime as incitement to genocide if there are no actual fatalities, or if there are no actual victims from a physical perspective. And yet, it's an inchoate crime, right? So my solution is that we have to explicitly drop causation. It is an inchoate crime. We should not be looking at it in the factual section of the opinions. And future opinions should be very clear on this. They should acknowledge that Akayesu confused things, and prosecutors should be more bold, and I think judges more receptive to the idea that incitement can be charged in the absence of resultant physical violence. All right, so we get a taste for incitement. Let's talk about persecution. And we recall that the elements that we looked at had the fifth one, which was the same gravity level as the other Crimes Against Humanity Acts. That's what I want to focus on here. Because there is a split between the ICTR and the ICTY regarding whether hate speech can satisfy the conduct element of Crimes Against Humanity persecution. The ICTY in the Cordage case said no, hate speech not explicitly calling for violence on its own should not satisfy the conduct requirement because it does not rise to the same level of gravity as the other enumerated crimes, right, such as murder, rape, etc. The ICTR said yes, the speech itself deprives the victim group members of fundamental rights. It excludes them from society, both socially and ultimately physically. And the Media Case Appeals Chamber, which could have resolved the split between the two tribunals, punted and didn't do it. So shame on them, but there was a lot of pressure. There were amicus briefs that were filed, frankly, by American interests. And you have, of course, Judge Marone, who is quite sympathetic to the American approach to this. And so, you know, it's the court, I think, was just, the panel was not prepared to deal with this issue. So we've got a split, and we've got, again, another aspect of fragmentation in the jurisprudence. The Media Case Appeals Chamber did note that hate speech standing alone may result in violations to the rights of the dignity or security of the group. I will acknowledge that, but just refuse to opine whether those would be as serious as the other enumerated CAH offenses. So the question arises, should they be considered as serious, and should persecution, hate speech as persecution, be considered legitimately a crime against humanity? And my answer in the book is yes, when you consider the chapeau elements of the offense, the specific characteristics of persecution, and the jurisprudence and commentary on speech and persecution. Let's unpack those for a moment. The chapeau elements, recall, tell us that the speech must be uttered as part of a widespread or systematic attack against a civilian population, with the speaker aware that his or her speech is part of that attack. And empirically, these are government-led attacks where the channels of communication are monopolized by the state and dissenting voices cannot be heard. And at the ICC, we know that it has to be a state or organizational policy. So it's absolutely explicitly linked to that. And so I would argue that if you look at the American, and I talk about this at great length in Chapter 2, and there's a method to my madness, because now I'm going to come back and talk about the American philosophy of free speech, which emphasizes so much the idea of the marketplace of ideas. You know, the idea, of course, is that ideas can compete with one another in the open marketplace, and that the ideas that make more sense will come out ahead in the end when people have a chance to discuss them. I was talking to Emma Irving on the way over here about the use of social media and whether, you know, the great framers of First Amendment jurisprudence would have considered social media, and whether the idea of the marketplace of ideas functions effectively with social media. Whether that's true or not, I would submit to you that in the context of a widespread or systematic attack against the civilian population, that it does not operate the way it's supposed to, that because these tend to be state-organized attacks, there is a monopoly on speech that the state holds. Judge?
What about ISIS?
Well, ISIS controls, even if you don't consider them a state, remember it also applies to an organizational policy. ISIS controls the area where it's currently still in power. That's increasingly becoming smaller. But certainly for a long time, in the last couple of years, ISIS controlled a wide swath of territory and clearly monopolized all channels of communication. So it's a good question, but I think there is an answer to it. And I think we probably would all agree that a widespread or systematic attack against the civilian population was taking place in the areas that ISIS controlled, and that went hand in hand with ISIS's monopolization of media channels in those areas. So I don't think American free speech principles or foundational assumptions apply in those situations, and therefore it takes it out of the things that I think Judge Marone should not be concerned about. I hope he reads the book. Kind of half hoping I might see him here tonight, but oh well. All right, so that's the chapeau. What about the specific characteristics of persecution? So international courts have taken an extremely broad view of conduct that may constitute persecution. And based on this liberal approach toward defining persecution, a number of important principles can be gleaned. And I put them up here for you. Persecution is not limited to infliction of physical injury only. Mental or economic harm may also be its object. Discriminatory acts charged as persecution must not be considered in isolation. Instead, all discriminatory acts within a case's common nucleus of operative facts should be considered cumulatively and within the proper context. So this whole idea of trying to understand speech, hate speech in a vacuum, the way the Grotius opinion does, which we'll talk about in a moment, is kind of ridiculous. It flies in the face of the jurisprudence. And acts that are not inherently or statutorily criminal may nevertheless become persecutory and criminal in the proper context if committed with the requisite discriminatory intent. And then based on all that, a narrow definition of persecution is not supported in customary international law. That's what we can glean from those principles. All right. So remember I told you Dietrich could come back and be important? We're now back at Dietrich. Let me talk about why I think it's so important. Streicher and Fritzsche have been, I think, used by a lot of experts who have said, hey, look, Streicher stands for the proposition that hate speech without explicitly calling for action, which is kind of what the Grotius situation, the Grotius panel was looking at, that does not, that does rather constitute persecution as a crime against humanity. But there are parts of the Streicher decision, especially the last part of the judgment. It's a very small judgment or decision, where it talks about Streicher speaking and calling for the extermination of Jews at a time that they were being massacred in the East. And so people will cite to that and say, but you see, there it says that you cannot have a charge of hate speech as persecution unless the defendant is actively calling for violence. Versus the first part of the opinion that says, for his 20 years of hate mongering in his paper, Streicher infected the German people with a virus of anti-Semitism, and that sort of suggests that hate speech as persecution does not have to be calling for action. Well, guess what? If we can look at that and we look at the acquittal of Fritzsche, which, by the way, is a very flawed decision, and I always talk about the fact when I talk about the Fritzsche case that that's either a complete article or a book in and of itself that I want to write. Let's forget all that. Let's just assume that those pieces of jurisprudence are at loggerheads with one another, and let's look at Dietrich. They're always overlooking Dietrich. But the fact is that the NMT in Dietrich dealt explicitly with a defendant who was not calling for action. Rather, he was infecting the German mind, again, sort of using the language of Streicher, with hatred to prepare them to commit the Holocaust. He was conditioning them. And so that is the best support for saying that hate speech not calling for action can constitute persecution as a crime against humanity. All the relevant World War II cases, I think, support this except for Grotius. And Grotius is deeply flawed, as I was suggesting earlier. So there we have it. All right. The other two offenses that I'll talk about briefly are instigation and ordering before I look at my unified liability theory. And I'm looking at the clock and realize that I better get humming here. So I can talk about this stuff for hours. I mean, it's tough to stop myself, but But with instigation, thank you. Christoph will take care of it for me. We have prompting and resulting and then contribution. Those are the issues that I see. The problem, again, is Akiezu's original sin of commingling the terms inciting and instigating, or incitement and instigation. And the sessional trial chamber judgment gratuitously shoehorned into instigation's actus reus element a different forms of persuasion requirement, which is beyond merely provoking, which is what all the other cases said you needed to have. So it had to be something like making threats. And that just was spun out of thin air. And unlike incitement, there is a degree of required causality, right? Because there needs to be a contribution. But the way that contribution element has been defined has differed significantly. So what I think we need to do is, kind of like with incitement, we need to have very careful language in the opinions that distinguishes between the two. We need to eliminate the different forms of persuasion element completely. It comes out of nowhere, and I don't think it's supported. And then, as I talk about at greater length in the book, what we need is a substantial contribution standard, and I explain why I think that strikes the right balance. As far as ordering, the key there is when a crime is committed. And I'm going to kind of briefly talk about the fact that what's amazing about ordering is that it's not an inchoate crime. Incitement, which involves typically a stranger talking to other people where there's no pre-existing relationship necessarily, that carries inchoate liability, as I talked about earlier. But not ordering, even though there's a superior subordinate relationship, as we saw earlier, that's part of the elements. What do you think is more inherently likely to happen in terms of subsequent violence if there's a superior subordinate relationship versus if there is none? It's a lot more likely that there will be subsequent violence in the case of a superior subordinate relationship, and yet it's not an inchoate crime. So my solution there is that there should be inchoate liability for ordering. All right, so I've now kind of gone through you see, now I wasn't just gratuitously talking about Donald Trump earlier when the kind lady over there was expressing concern about Trump. It factors directly into my presentation. And here what I want to say is, amazingly, despite the fact that the battlefield is probably the most inherently violent place on earth, there is no offense of incitement to commit war crimes. And in the book I explain historically why that should be a problem and how we can fix it. And I look at the Geneva Conventions, I look at the Hague Conventions, I show that there's an absence, and then I recommend changing those instruments and the Rome Statute in Article 25 to include F, right? E is incitement to genocide. F, I suggest, should be incitement to war crimes. All right. Now, the grand finale, my unified liability theory. Here we are. So remember how we talked about the way that this body of law developed through sort of fits and starts, Nuremberg and the Genocide Convention and then the ILC and the various ways, dealing with the atrocities in the Balkans and the fact that the ICTY statute had to be drafted in fairly great haste. There's a lot of cutting and pasting that went on. There was not a lot of reflection about how the law might fit together and whether its pieces could be more effectively, if you will, constructed as a whole body of law. And so what we get are these 4 different offenses that don't really fit together. And when we look at it and think about it, what we have is incitement, which is speech uttered in advance of violence, but no violence occurs. And that only applies to genocide. Why on earth is that? Why should it not apply to crimes against humanity or war crimes, as I talked about, for example, in Chapter 10? And then persecution. If you think about it, what is it? It's speech uttered contemporaneously with violence. It only applies to crimes against humanity, and it requires a severe deprivation of a fundamental right, as we saw. Instigation is speech anterior to violence that actually takes place, and ordering is speech anterior to violence that actually takes place within a superior subordinate relationship. And they and all of the instruments are separated from the other speech modalities. So they're fragmented in terms of the way you find them in the actual statutes. So one of the things that I do is I propose the crime of speech abetting. Because why should we have speech that is contemporaneous with violence limited to crimes against humanity? And why should we saddle it with a severe deprivation of rights requirement? Let's untether it from that and have it apply to the other core offenses. That way we can cover contemporaneous speech. So, what do we get? When we come up with the unified liability theory, what we have is we see speech anterior to atrocity, and we see that divides into catalytic and non-catalytic speech. Catalytic being instigation and ordering, and non-catalytic being incitement and ordering, because under my theory, ordering, remember, should be an inchoate offense. This would fix the problem on a holistic level. And then remember, speech synchronous with atrocity, which is non-catalytic, I argue by definition, because if it's catalytic, then it's not speech abetting. That should be speech abetting, and it should apply to each of these core crimes, right? Aggression has a question mark, because we're going to see what happens this year, right, with respect to aggression. We don't know. And then here's persecution, a little bit off on its own, because it does deal with speech synchronous with atrocity, and in the book I say it should remain. There's no reason why it can't be charged along with the other crimes. It's just sort of a sui generis crime that can still apply. All right, so in my view, this should fix everything, and the way it should be operationalized, as I point out in the book, is via treaty. So I actually have a draft of the Convention on the Classification and Criminalization of Atrocity Speech Offenses. And then for new ad hoc tribunals or domestic jurisdictions, the contents of that treaty could be used to put into a statute. And then via amending the Rome Statute by adding Article 25 bis, which would include incitement, speech abetting, instigation, which is obviously provoking or inducing currently in the Rome Statute, and ordering. That is what I have, and I'm now ready for questions. Thank you very much. And go easy on me. I'm very jet lagged. I just got it in from Hong Kong. But really, don't go easy on me.
Thank you very much for this very extremely clear presentation, I would say. And I think you did not only describe the law as it is in a very clear way, but you also, it's clear that you contribute to the development to the law in a very innovative way, with your unified liability theory, the speech abetting, etc. So I'm sure that many people will have some questions for you ready. There are a couple of experts in the room, for sure, I know. Yes, Emma.
You got a mic coming in.
Oh, we do? Oh, that's exciting.
Yes.
Yeah.
So, thank you very much for that. I am, of course, familiar already with some of the content that you've put forward tonight, but it's nice to get a refresher. So, as you hinted at, my questions are going to be social media related.
Sure.
Just because I think it's going to be the biggest way in which hate speech is put out there and disseminated.
For sure.
As we go forward. So, I take on board that you want to get rid of this idea of the direct requirement in incitement.
No, I don't. The public requirement.
Sorry, public.
Yes,
It's
not
public.
direct.
But my question would be, sort of assuming that we don't get rid of it, or that for the time that it's still there, how do you see social media in that respect, in the public sense? So at what point does me posting to my Instagram or my Facebook become something that I'm doing publicly? Does it need to be shared? Does it need to be retweeted? Do I need to have over a certain number of followers? Does it need to be liked, and so on and so forth? And is there a line that we can draw? Should we draw a line, or is it always public? Then you can go down the rabbit hole of privacy settings. What your privacy settings on when you publish this stuff? And also, sort of, I suppose, in that similar vein, how do we see images and videos and that sort of thing when it comes to just, I suppose, speech in general? Like, how do they fit in? But that's maybe more of a sideline. And also, I want to push you on this idea of marketplace of ideas.
Sure.
In the social media context, because it's almost part of the point of social media is that it's very difficult to monopolize.
Yes.
And it's true that you can shut it down, in the sense if you shut down the internet in certain areas, you can start to interfere with it. But for example, when we saw the fall of Aleppo, like there was so much social media content that came out of that perhaps we don't see in the ISIS controlled territories because they've been better at shutting it down, and maybe they have monopolized it over there, but there's an awful lot of other situations we see where atrocities are taking place where they haven't managed to shut down social media. So is it really being monopolized in the way that you suggest that would back up what you're arguing?
Okay, great questions. Thank you. So I anticipated that I could get a question like this, and so I have a couple supplementary slides. And I'm going to go to one of them. And what you can see here is that within incitement, I have a more of a holistic solution. I just didn't have time. I just gave you public and causation. But one of the things that I think when you look at incitement itself, as that is an element. I didn't have time to talk about that tonight, but you can see I also deal with direct, and of course causation and public as we talked about, and I'll get your public point in a second. But one of the things that I believe that when we look at incitement itself is that we need to look at these elements, and one of them is channel of communication. How is the speech uttered? So in my view, the relevance for the law is in terms of whether this constitutes incitement. And I would argue that if you're looking at social media as the medium in this particular case, that's more likely to be considered incitement than, say, print media. I think that's kind of where it comes in. The notion of whether it's public or not, I think this goes to the same problem that we saw, for example, with the roadblock cases. So you could say, well, the social media cases are kind of another example of it's just a different place, right? It's more of a virtual place. But it's just as the roadblocks are physical places, social media chat rooms or Facebook accounts or Instagram or Twitter, those are virtual places where should we be all that concerned whether it's 5 people or 10 or 100 or whether there are privacy filters? Why should that be a function of liability? I don't think it should. And then in terms of how that affects the idea of the marketplace of ideas, that's, I think, more of a, I mean, it does factor into incitement to a certain extent, but I think it's really more of a persecution, hate speech is persecution issue. And there, as far as I'm concerned, if you were able, and I talk about this at great length in the book, it's just there's not time for it tonight, obviously, but I talk in the chapter on persecution and the solution. I talk about the fact that we've got to look at cases individually on a case-by-case basis. So we could have a scenario, and I talk about different scenarios in the book, where there is not effective monopolization, let's say because the main platform in that area is social media. And therefore, we should be a lot less reluctant to charge hate speech as persecution in that context. So, really good questions. Yes, got another one. And we got the judge back there too.
Thank you very much for taking time. Does this work?
Yeah.
Okay, great. Thank you very much for taking time to share a summary of the book. I'm looking very much forward to reading it.
Wonderful. Glad to hear that.
A question related to the ICC case that is now on trial.
Yes.
So very famously, the RTI, the National Ivorian Television, was broadcasting all this, what used to be called hate speeches by the 2 actors on trial, specifically by one in particular. Now, it's very hard under the elements of crime and under CAH at the ICC to prove the state and organizational policy, which is mandatory, right? And that's like the extra layer of the ICC that brings to the game. Now, what's very interesting for me is that there's this charge of persecution against Blegudet, and I'm curious if you expand a little bit on this, on the state and organizational policy that have to be, attacks have to be committed in furtherance of. And specifically, how do you see the ICC case evolving in that sense? What do you foresee as difficulties with this extra layer added?
I appreciate that. Thank you for your questions. I feel a little compromised because I actually served as a consultant to the prosecution team on that case. So I have some insights, but I haven't followed it as closely as I should, as the evidence has been unfolding during the trial. Yeah, I mean, I'll be honest with you. I mean, it's something that we talked about when I was consulting with them, and I think it can be tough at the ICC to prove that. look, I mean, I think Blake Gaudet is a very clever guy, and he kind of knew. I mean, he was looking at ways, I think, of trying to, skirt the law in a way that he could do what he wanted to do for Gbagbo, and yet, maybe not get caught. And so it's a tough case for the prosecution in that regard. I'll tell you my view, and it's interesting having Judge Van den Boeingart here. I think that we should be rather liberal in our interpretation of state organizational policy. I don't have a problem with that. I'm not going to lose a lot of sleep, frankly, with a fairly liberal approach to that requirement. And my sense is, I think especially from the Kenya case, that there's an argument that that's there, that it's a fairly loose, requirement. But I don't go into that in the book a lot. That could be the subject of an article, honestly, a separate article. In the conclusion, I talk about a lot of paths for additional research. So if you do read the book, I would highly recommend that you look at those. That is not one that I particularly looked at, but I kind of wish I had now. I know we're talking about it. I think I felt, because I helped out with the prosecution in that case, that I've been a little tight-lipped about talking about my views, to be honest with you. So, maybe I would have been more expansive about it or engaged with it more, but I don't talk about it very much. Thank you.
Professor, my name is Khalid Ahmed Chaudhry.
Yes.
From International Human Rights Commission.
Nice to meet you.
Thank you. My pleasure. First of all, I wish if you could continue for another couple of hours.
Thank you so much. I appreciate it.
Because you have full in-depth command of the subject, so it was extremely interesting for all of us.
Oh, thank you so much.
I have two questions. One goes specifically, we are talking about the hate speech.
Yes.
And I was thinking about the cartoons, Muhammad cartoons.
Yeah.
In Denmark, in Charlie Hebdo issue and others.
Yes.
If you would like to say something about that. And the second is, before this unfortunate terror attack in Norway,
yes,
Mr. Breivik was sitting in London, where Mr. Wilders, Dutch politician, he made a speech. And after some times, Breivik committed this
atrocity. Yeah.
Then again, last year in December, Austrian courts, they wanted to prosecute Mr. Wilders for hate speech.
Yes.
A hate speech in which he compared Quran with Mein Kampf.
Terrible.
The prosecutor, they asked the Dutch prosecutors if Mr. Wilders can be prosecuted in Netherlands or something. But according to the Dutch prosecutor, it's an offense which Dutch law cannot prosecute him. We are facing a scenario and situation, terrorism, extremism, fanaticism, not only from Muslim sides but all over the world. It is. Whenever media hammers about Islamic terrorists, Islam, terrorism, etc., etc., so and some imams take advantages and they create some kind of to help radicalization within the Muslim youth.
Yes.
So who is responsible for this? Are the acts of that youth, like UK, someone has committed this. So who is responsible actually? That we are leaving, we are just taking those boys, into custody. We are putting them on a trial, and those who are responsible, the media, the European media, the other ultra right-wing leadership, which is making that kind of speeches and creating, a hell of hatred. So nobody is talking about that. So if we can hear something about this.
Okay. Yeah, no, I appreciate that. It's funny, but both your questions reminded me of a couple of talks that I've given recently at the United Nations. Your first question, we were talking about the cartoons, the Danish cartoons, and the disrespect that was shown Islam in those, and some of the other examples that you gave. I got a question. I gave a talk at the UN last month, and people were saying, well, you're talking about genocide, you're talking about crimes against humanity and war crimes. What about all these other horrible things that are going on that are connected to hate speech? And what I had to say is, well, look, there's 450 pages of this. I could, could write, several volumes if I were going to go into just the other crimes in the relationship. I don't do that particularly in this book. I mean, we could certainly talk about it, and I certainly have ideas about it. And I do want to say that I'm very sensitive to the fact, and I say this with my fellow country persons in the room tonight, that we have to strike the right balance between protecting free speech and prosecuting acts of hate speech. And that's a tough balance to strike. And I don't know that there are any definitive answers that I can give you here. My own thinking is fluctuating to some extent on this issue, to be honest with you. I think one of the problems that we have in the United States, if I can focus on my own country for a moment, is I think we need to disambiguate dissent from discrimination. I think somehow we've coupled them, and it's a mistake. I should be able to rail against the United States government at any time of the day, anywhere, any place, and I think saying anything as long as I'm not trying to plan a specific crime that rises to the level, say, of conspiracy or something like that. But if I'm just expressing my opinions about Donald Trump, for example, I think I should be able to do that without any problem whatsoever. On the other hand, if I get on the radio and I say terrible things about my Islamic co-citizens and dehumanize them and refer to their holy book as Mein Kampf and things like this, I think that should be prosecutable. And I think we're not doing that in the United States. Now, I think we have to draft the law properly. But let me just say to you that those laws are on the books, notwithstanding the fact that it's interesting that the Dutch were saying, well, they couldn't prosecute Wilders. The Dutch have it in their statutes. The Danish certainly have it. Almost all Western European countries have those kinds of laws. You were talking about Austria. They certainly do. That's where Adolf Hitler came from. I think we have to make sure that we're very careful about what we're speaking about. But I generally support the ability to prosecute for hate speech. I think you have to be very careful about how you draft the statute. But I don't see New Zealand and Australia and the Netherlands and Canada and the UK and all these places going to pieces because they have those laws on the books. Now, your second question, it's weird. I mean, I don't know why I got 2 invitations to speak at the UN in the last few months. The other one was on incitement to terrorism. So I gave a talk at the UN on incitement to terrorism. The UK has a very broad law, by the way, on incitement to terrorism. I talked about that a little bit. So, of course, all these jurisdictions, especially the adversarial common law jurisdictions like the United States and the UK, prosecutorial discretion is a huge part of whether cases get charged or not. And sometimes that can be problematic. The law can be really beautifully written. It can be, perfectly tailored. And yet, if the prosecutor doesn't use it properly, then it doesn't really matter, right? If the government officials don't do their job properly in court, it doesn't really matter. So, all of this has relation to what I'm talking about in my book, obviously. And obviously, Chapter 2 is linked from a policy perspective to these choices that we have to deal with in international criminal law. But I don't specifically deal with those issues in the book. But in the conclusion, I talk about the fact that we need to. Another area, by the way, that I talk about that needs to be explored in much greater depth is the issue of denial. So if you talk about a place like Germany or Austria, you're dealing with Holocaust denial, for example. Should that be a crime? That's a tough one. And it's related to what I talk about in this book, but it's not exactly on point. You're not going to see denial charged at the ICC or at the ICTY, for example, unless it's related to crimes that are going on now. So thank you for the great questions. Appreciate it. Yeah.
There was a question from Judge van der Beekhaat, and then maybe the lady opposite. Yes.
Let me join the congratulations.
Thank you,
thought
Judge.
It was a very interesting speech, very thought-provoking.
Thank you.
I have a question which is also somewhat outside of what you were dealing with, and that's about the internet and radicalization.
Yes.
And the question, to what extent internet providers, social media can be accomplices to hate crimes. Think of ISIS and this journal that they circulate via the internet.
Yeah.
Is there something that can be done, and if so, what?
That's such a hot topic right now, and it's a great question. I think the providers are starting to take this a lot more seriously, and when there are modifications in the law, you see that they start taking complaints of radicalization communications a lot more seriously, and they react to taking them off of their platforms a lot more quickly. So I think the law needs to be tightened, frankly. I think they have to be incentivized more greatly to be reactive to cases of radicalization where speech is being used on their platform to recruit or to incite to acts of terrorism. That said, again, we have the sort of the pushback, which I think we have to be very careful about, is not to go too far, because we still have the issue, where do you draw the line between, say, talking about horrible things that the United States has done, for example, in the Middle East, to recruiting for ISIS. Sometimes that can be a hard line to draw, and I think, again, we have to be extremely careful about the way that we draft that legislation. But I think it's doable. I think we need to do more of it. But this is an area where lawyers and judges and scholars are so crucial to how the law is being used. We all have to be watchdogs in this area, both in terms of complacency for lack of enforcement, as well as overzealous enforcement. This is an area that is rife with, I think, extreme approaches on both sides, and it's incumbent upon us to be vigilant. But there's not enough out there now, in my opinion. I think we're going to see more legislation. And I have to say, the United States, the United States is a big culprit in this regard, because it's the Wild West. And I think a lot of extremists say, well, there's a problem doing this in Denmark, or there's a problem doing this in Canada. We'll go to the United States. We'll do it in the United States. And I'm just really concerned about my country being the ideal repository and disseminator of speech that's clearly fomenting terrorism and genocide and a lot of terrible things out there. So, it's funny. The United States does so much preaching about how other countries need to, fix their laws, or that the United States is a model. I think our law is wholly inadequate when it comes to this. So that when you talk about that, Judge, from a perspective of looking at my own country, that's I think probably the prime area where it needs to be focused. Thank you.
Yes.
Thank you very much for that. So I'm very interested in your proposal that causation be dropped as a requirement, because it is such a pillar of criminal law.
Sure.
So is that a proposal that you make is there any support for this domestically in any domestic jurisdiction? And is this based on the widespread and systematic attack context? So would you say in ordinary domestic law one still needs causation? And then finally, in South Africa, where I'm from, there is a very hot debate about the criminalization of hate speech at the moment, hot hate speech. And the argument, it's a very unpopular proposition by government because the fear is that it will be politicized, right? And isn't that fear just as acute in international criminal justice context, right? Where we see politicization so strongly. I mean, the Nazi context is a nice context in the sense that it's a clear context, whereas we know that this is not always the case. Thanks.
Yeah, sure. So going to your first question, I think, there's an assumption that you're making that probably you shouldn't make, which is that causation would ever be considered a requirement in the first place. It's very clear that it's not, even though, like I said, the decisions have dealt with it ambiguously. I'm not really calling for it to be eliminated. I'm calling for the situation to be clarified, actually. And why is that? Because incitement is an inchoate crime. So if you look at my unified liability theory, what you're talking about is speech anterior to atrocity that is non-catalytic. So by definition, that means that there's no causation. If there is no causation, then you should be treating it essentially as incitement. If there is causation, then you should be treating it as instigation, or if it's in the context of a superior subordinate relationship, you should treat it as ordering. So that's, I think that first of all, that has to be clarified. Then you talked about it, what about the widespread or systematic attack? But incitement as it stands now only applies to genocide. So I don't know if this is what you were getting at, although it would be interesting to have this discussion. If my unified liability theory were adopted and incitement applied to crimes against humanity, I deal with that a lot in Chapter 11. So I go through sort of the theoretical, I kind of do the, if you will, exercise of, how do we play this out theoretically and look at the relationship between the speech and the chapeau elements and all that. And it was kind of fun to write that chapter, actually. Chapter 11 was my favorite chapter to write because it was the most, as you said, normatively challenging, if you will. But I'm really not all that concerned about it. One of the things that I'd like to say that I think is interesting, not so much the chapeau, but the specific enumerated offenses. So, I'm just talking generally, we should have incitement to crimes against humanity. But I think if you look at it more realistically or more practically as a charging decision, maybe what you're talking about is incitement to murder as a crime against humanity, or incitement to rape, or incitement to imprisonment, or whatever it might be, that you can actually look at incitement to the specific enumerated offense, and probably that's what you should. I think practically, that's the way it would be charged, although I suppose you could maybe theoretically say that you would have incitement to crimes against humanity, but I would think pretty much in the indictment you would have to spell out what the enumerated crimes were. Even if you had like a general charge and then had it subdivided. So it brings up all kinds of interesting charging strategies. Your last question was about the politicization, and it's the same question that I was posing earlier. And when we were talking about it from the perspective of the hate speech that's been levied against Islam, there are cases where ISIS is recruiting, and it's bad, and it's wrong, and it's chargeable, and it's incitement to commit terrorism. And there are cases where there are legitimate grievances, say, against the West for things that are happening in the Middle East, and that there should be an avenue for talking about that. And, I worry about dissent in that context being criminally handled. This is the problem with speech every time. This is why it's fascinating to write about it. I feel very lucky and privileged that this ended up being, I was assigned to the media case. Obviously that changed my life, right? It was luck of the draw. I could have been assigned to any case at the ICTR. It was, the day that the person, when I arrived, the person said, we're going to put this guy in the media case, and it completely changed my life. I happened to walk into this incredibly rich area of law where issues of politicization and self-actualization and the flourishing of democracy, and I mean the most fascinating fundamental issues that we deal with in the law are implicated in this area. And I mean, to be able to talk about it is an incredible privilege and honor, and to be able to do it in a venue like this with all you experts is just wonderful. So thank you for the good question. I don't know that there's any one direct answer that I can give you, unfortunately. Have any other? I could, as you point out, I mean, you can tell my enthusiasm for the subject. I could probably do this all night. Even though I'm jet lagged, I'm surprised. I think the adrenaline kicked in, and, you were such a great audience. But, yes, ma'am, please.
I can talk all the way. I don't need the mic.
Yeah, it's for the video, so maybe,
okay. Hi, so I'm actually one of the students from American University.
Okay.
And so I think one of the concerns that I hear a lot of from, we talk about this in our peer groups, and my family's raised this issue too, is, what do we do with the speech that Trump is coming out with that isn't necessarily calling for attacks, but I think has a lot of people concerned because of the number of hate crimes that we've seen rise. You can't really call it necessarily state policy, because he's kind of gone rogue on Twitter a little bit, but there have been instances where there's a suit going on of somebody at a rally who he incited the mob to attack,
right,
and things like that.
Yeah.
So sort of where do we sit with? Which
survived a motion to dismiss, by the way.
Yes.
Yeah.
I can see that, so thank you.
Yes.
That's good news. But thinking about it in the context of the Dietrich case, it seems like he's almost he was priming the country throughout the election season, and now we're seeing so many more of those crimes. Where sort of is the line with public figure responsibility then, and how do we sort of go about looking at that, especially given that, as you said, the U.S. is the Wild West?
Yeah. No, I appreciate the question. That's kind of the question, again, that I got at the UN last month, or in April, when I was there, is, what about, what Donald Trump is doing in the United States? If you want to say that, atrocity is an international crime, unfortunately, those are not the kinds of crimes that he's engaging in. Now, when he was talking about ISIS during the election, and he was talking about committing acts of torture, and he was talking about killing the spouses of ISIS fighters and all that good stuff, then he was in the area of atrocity, right? Because he's inciting to war crimes, in my view. I talk about, by the way, if we adopt my ideas, that it would cover civilians. So in that case, he was a candidate for president of the United States. He would have been liable, in my opinion, as a civilian. If those kinds of crimes had been committed by U.S. soldiers, I think there would have been an instigation case against him. And even if the crimes weren't committed, I think a good case for incitement. There are going to be times, if the Trump presidency, I hate even saying that, survives, continues to exist, where I think we might be on the border of, are we dealing with an international crime, right? Because the title of my talk tonight was the law governing the relationship between hate speech and international crimes. What he did at his campaign rally, is a domestic crime, right? And and actually that motion to dismiss, that's a civil suit. So that's not even a criminal case. It's really hard to bring a criminal case in the United States for anything related to hate speech. But there are exceptions, and I talk about this in the book. I mean, you can prosecute hate speech in the United States. It's just really hard. So I think, we have to be especially aware of the things that Trump says. When he's tweeting things, now that he's president of the United States, you bet those are acts of state, if you want to call it that. That he's acting in his capacity as an official, as far as I'm concerned. It would be interesting for immunity purposes to analyze that, right? So, if we were talking about certain kinds of immunity, we might say, well, if it's, active state immunity, then, he would have it. But if it's personal immunity, he has it while he's in the office, but then he would lose it when he's no longer president. But I think no doubt that if he tweets something that is incitement to war crimes or incitement to genocide, and it's on his Twitter account, and Sean Spicer tries to deny that he said that, too bad. Talk about social media. That's a perfect example. I did a blog post for OUP, my publisher, recently talking about Spicer's comments about the Holocaust, and talking about the fact that the Nazis didn't use gas, and talking about Holocaust centers, making them sound like they're like bureaucratic units or something. I mean, just crazy stuff. And what I said was, what's that?
He said he didn't use chemical weapons.
That's right.
Yeah,
that's right.
Yes, but well, I agree.
Google my name and OUP and Sean Spicer, and you'll find my post, and I went into that in detail. My point was that while that may not be a crime per se right now, and I talk about this in the book because I talk about actually, this was another slide that I prepared in case.
Very well prepared indeed.
Yeah, well, because I knew I had time. But this solution that I offer is a glossary of incitement techniques. And one of them, which actually I don't think I see here, is denial. So denial in the right context, I say, could be considered an incitement technique. Now, was it in that particular case? No. No. But what I say in my blog post is, be careful, because the road from what Sean Spicer did to actually committing international crimes, that road gets traveled pretty quickly. And we have been seeing a degradation of values and norms in relation to speech and the potential for international crimes with what is going on in the world right now. With Trump as currently in the White House, Vladimir Putin, I mean, the list of Duterte in the Philippines. I mean, a lot of people have compared this time to the 1930s, and I am increasingly starting to think that there is a valid analogy there. So we can go there quite easily, and we have to be very careful. Ma'am, did you have a question or thought about that particular issue?
No, I agree with you that it was really stupid, but I think it was more stupidity than a crime, to tell you the truth.
Yeah.
And it was really bad that he made this mistake.
Yeah. I think it's more indicative of a mentality that allows us to see how easily we could get to the next stage of this. I think that's what it is. I mean, I think it's the idea that there could be a slippery slope. So,
And I'm afraid Trump is a lot of stupidity as well.
Yeah. Well, and I'm publishing this book. It's interesting from my perspective. I honestly think this is really timely. So, I mean, one of the reasons that, I want people to read this is to realize that if we don't fix the law properly, we've got a lot of people out there who are doing some really bad things, and speech is the basis for a lot of it. And so we need to get this law right. And, I'm hoping that all of you, have an ability to talk about it. I mean, we certainly have an ICC judge here, and we have policymakers, and we have students and teachers and people who are going to make a difference in terms of how the public perceives and deals with this phenomenon. So I'm really grateful to have this forum, and I guess that's probably as good a time as any to say thank you and appreciate it.